Shech Patchwai, good afternoon or good day. We have our A War Cry podcast today, and our intent is we're bringing you our fourth micro method workshop with content expert on MMIW, MMIP, and task forces. This is a collaboration with War Cry podcast, and our sponsor for this micro method workshop series has been Na'ilihi Fund. Again, this topic can be sensitive and triggering, so please take care while you listen. This episode of War Cry podcast, we're an all native run podcast discussing data, events, stories, issues, and historical connections about Northwest missing and murdered natives. We are located on the Yakima Reservation with headquarters in Toppenish, Washington, but with usual and accustomed places that extend throughout many states. We thank you for joining us for this episode, and we are happy to answer any questions you might have after. Just make sure to leave it in the comments or chat. My name is Emily Washings, and co-hosts today are Patsy Whitefoot, Robin Peebushy, and our guest is Chris Cuestas with National Violence Prevention Resource Center. I'll turn it over to Chris to introduce himself and go over the topic that we're going to talk about today.
Thank you. Good morning, everyone. And this is our fourth micro method workshop, and we're going to be dealing with the issues of basically forensic case examination and case analysis, and also how do we develop or follow a matrix for solvability, and then where do we get started. All along the way, what we've been trying to do, and the reason that we came up with this strategy, and the War Cry podcast has been an amazing partner, was we wanted to kind of assist the communities in developing their task forces, because that is probably one of the issues that are greatest challenges in a community, is to create inertia and positive energy around subject matter, whatever your topic is that you choose to address in the form of a community-based grassroots initiative. And there was a lot of delay with regards to, and I just spoke to a good friend of mine, also in the Pacific Northwest, and said, we were given a notebook, but we really weren't told anything else other than, here's a notebook from whatever group was used for the MMIW, MIP issues in the state of Washington and in the Pacific Northwest. So in seeing that, I talked to War Cry podcast and also staff, and thought that maybe we should assist from our level of experience in working task forces, initiatives, and tribal lands for. It's funny, an elder asked me the other day, well, and how long have you been doing this, young man? She asked me last week. And I said, well, ma'am, just a couple of weeks shy of 42 years. So I'm still a rookie. And she started laughing. She goes, no, I'm pretty sure you're an authority now. I said, well, thank you very much. So that's our intent. And get into our material real quickly here. And it's kind of, it's a positive negative, because I'd like to keep going and keep presenting materials and information based upon what I've gathered along the years of working with tribal communities. But I know that, there's other issues that are pressing in tribal lands, and hopefully we'll come up with some type of opportunity to speak with you again. But I really enjoyed doing this, so we'll go ahead and get started. As I indicated, this partnership has been amazing for me, and I really enjoy the War Cry podcast team. Very professional, very well done, and I'm very excited to see what we can come up with in the next phase of our relationship. So I want to thank the staff. Our last session, as you were aware of, I came down with the old bug, and so we had to be pre-recorded. I don't know, and hopefully if there was any inquiries or any responses that were triggered, that we can try to answer them along the way. But your feedback and your input is always special and very important to what we're trying to accomplish. If you remember, the task force idea and the concept was to address and to develop behind the MMIW, MMIP issues and culminate in the pursuit of getting some of the questions answered regarding cold cases and missing and murdered Indigenous individuals and women. And that's been the focus of our micro method workshop. We wanted to get you to be able to be developed to that point so that you can begin to take on some of these challenges, because these cases are not easy cases. And a lot of times they're soul draining because they're so hard to work and to be able to follow up on. And the strategy was to accelerate the task forces in tribal lands and move into case management and cold case inquiries, because you can't get these questions answered in tribal settings unless you have a collaborative and you're moving specifically and directly on those issues. So we want to get on to the next step of, now that we've developed this task force, now that we've come together, we've written our procedures and our protocols, and we have our personnel in place, and we have, if you decided to develop subcommittees, which is always a good idea, how do we accomplish the working on these cases and getting some inquiries and some questions answered? And I think we need to start by having some issues that we're going to cover. We're going to cover the concept of case status with regards to cold cases. And then what does it take to reopen a cold case? And you do have to create another wave of energy to get a cold case reopened. And then how do you get the information? How do you get access to those particular cases, or the case file, or the case package? And all those terms are critical, because you can't just go up to an agency and say, hey, I want to look at a closed homicide case. You have to be specific on what you're looking for. So I want the case file. I want the police reports and all the specific data regarding our particular victim. And then, it comes down to whether or not the case is solvable. So I've got a matrix that we can screenshot and go over so that you can distribute amongst the community members. You're not going to find this information commonly, because it's very draining as a case agent to go to a family and tell them that the solvability of your case is very, very small. But the more you're missing on a case file or case package, the less likely that it's going to be solved. And that's just the nature of these types of investigations. So we'll review the solvability matrix. And there's also a way to use that solvability matrix to be able to give you a start and give you insight on the specific case of the individual that you're looking into. And then where and how do we begin? So let's begin by looking some of the history of what cold cases are. A cold case is defined as an unsolved murder, unresolved murder, long-term missing person, unidentified human remains, or an undetermined death. That's kind of the framework that determines what a cold case is. What's some history of some cold cases? Well, unfortunately, in our country, there's been an estimated 242,000 unresolved homicide cases from 1980 to 2016. It doesn't seem like a lot for a country this vast, but that's roughly 40% of homicides remain unsolved. And that's kind of eye-opening. A lot of people don't understand how we could get, in this day and age, have that many cases that are unsolved. The clearance rate for homicides plunged from 78.3 in 75 to just 59% in 2016. And what you're looking at is a seismic shift on these types of cases. And experts in the field will tell you, researchers will tell you, that there's a good possibility, especially with all the negativity surrounding law enforcement and driving recruits and professionals away from the law enforcement career field, that we're going to see a greater decline in homicide cases, solvability of these cases. It bears to mind that the community needs to become more involved and become more active. Unfortunately, you're seeing some real subtle shifts in how these cases are worked. And if they're not perfect, a lot of times these cases don't go anywhere. And I can tell you that from my experience of working cases for over 20 years, I saw very few. I can count in one hand how many perfect cases I actually took to trial. So you don't get perfect cases. There's always some major gaps. There's always minor details that are you can't come up with theories as to why certain issues happen. I've heard that one of the big concerns is prosecutors demand a pristine timeline. Well, that's virtually impossible to get on a homicide case, because you can't account for absolutely every step that an individual takes before they become a victim. And I think a lot of the cases are internally dismantled before they ever get to a point of going to trial. And kind of give you a little bit of experience / information. What happened in our country, and I think it's in the time frame that we're looking at. The trier of law, T-R-I-E-R, trier of law is a judge. That's what the judge does. The judge sits on the bench and tries the law that is being charged to the defendant. The trier of fact is a jury, unless it's a bench trial. Then the trier of fact is the judge makes the ultimate decision. But what happened in between this time frame that we're looking at, prosecutors began to assume the role of becoming triers of fact. So they dismantled the cases before they would ever get to a jury. And that's unfortunate. It would be very interesting to do a research piece on why prosecutors took on that role, because that's not their role. They're an arbiter of the case, is what their job is. The detective creates the investigation. The prosecutor is the arbiter, but the actual trier of those facts is a jury. It's usually a jury of the peers of the defendant. For some reason, that was derailed in our criminal justice system, and this is some of the evidence of that. They're not allowing these cases to get to a jury, and they need to get to a jury, and that's why we have so many cases that are just unsolved or uncharged, and that's unfortunate. And the greatest example of that is the declination rates in tribal lands. The declination rates in tribal lands is over 80%. That means that they decline over 80% of all the cases that come to them. And one of the highest, which is just amazing to me, is it's an 88% declination rate of sexual assaults. And that's just uncalled for. And those, I think, are some of the real gaps in this process that I believe need to be addressed, and questions answered as to why we are having so many of these cases that don't go anywhere. And these numbers are staggering to me within that time frame. So cold cases are an issue that is really a detriment to the criminal justice system. And there's going to be challenges during your inquiries as a task force regarding cold cases. Not every agency investigates cold cases the same method. They don't use the same methods. And one of the things that we tried to suggest years ago was to have every department follow a cold case checklist. And that somehow that was interpreted as an insult or challenging that they know how to go about their business. But when you get a case and there's things that aren't done on that case, it basically develops a support of that concept of having a checklist so that every agency follows the same process and the same protocol for those investigations. Because someone can close it based on a witness issue, or someone can close it because the defendant doesn't want to talk, or someone else can close it because they lied to federal law enforcement, or witness-related issues. Well, as I indicated, every criminal investigation has witness issues. You're not going to find a case that has pristine witnesses in our cases. So you have to kind of build that into the response of dealing with your investigation. And you're going to uncover when you begin to look at these cases, and that's the idea, is to pull these cases in and review them and look at the case file of the case package. You're going to uncover some inappropriate behavior. You're going to find some procedural flaws, and you're even going to find some lackadaisical responses to investigative leads, because I'll be the first to tell you that in our society, American law enforcement has a need to blame the victim. That's just the way that it is, especially if the victim had any history with drugs or alcohol or promiscuity or any of those issues where in their mind led them to the position to where they ended up becoming a victim. But that should never be part of the reason why a case is derailed, because that victim still has alienable rights, and there's still a responsibility as a justice system to bring justice to a victim. And as a task force, you're going to cover a lot of these issues that are going to potentially sidetrack you, or bring attention to some improper behavior. But don't lose sight of the fact that you're working on behalf of the victim and on behalf of closure to the family. And that's what drove me in my cases, was that it was a bit controversial, because I never felt like I was working for the police department. I always felt in my heart that I was working for my victim, and my victim needed justice, and my job was the pursuit of justice for the victim and the family. And the department was basically my sponsor. But they didn't like that, because they want to be able to navigate the manpower. And you end up having to realize, and you get to a point in your career where what's more important. And to me, it was always the victims, especially when I was working violent crime and crimes against children, is bringing justice to the victim. So just some important information to know about when you start pulling information in, what you're going to find. Some of it may be quite disturbing, and just basic report writing that should be one of the fundamental foundations of law enforcement, is appropriate report writing. But a lot of times, and some of you may even have gotten some information that there's not even reports written. They don't take the time to actually write a police report, much less write it accurately, appropriately, or using proper language and sentence structure. It's really unfortunate, but it's a reality of the criminal justice system. So, reopening a cold case. Does anybody have any questions before we go on to reopening a cold case?
I think there was just a little bit of clarification for us that are not prosecutors and aren't law enforcement. This term about being solved and about having a clearance rate. I think I want to just recap that really quickly, and to say that the clearance rate for law enforcement means an arrest typically. And those are terms that are utilized by a reporting program, basically a federal reporting program that defines that. And solving I think what most common people and community members like myself think is in the courtroom, being prosecuted, having a conviction. And so those terms aren't necessarily the same, but as far as law enforcement can go, sometimes they can only go to the clearance rate, which usually means a charge, or in the event that the person has died or the suspect has passed away, that they've taken that as far as they can go.
Yeah, and there's a couple of options for closed cases. There's a close by arrest, and there's closed by other, which is the scenario you talked about, which means the defendant or someone key to the investigation has expired, and therefore the case can't go any farther. There's exceptional clearance, and exceptional means that there's an exception as to why that case was. For example, if you're working a couple of burglary cases, And the result of that burglary was someone was murdered by that suspect during the course of the burglary. You charge him with the murder, and the other burglary cases are closed by exception. So it basically becomes a priority. And then there's closed unknown. And unknown is basically just an open classification for a case. And those are normally cases that are embroiled with maybe witness issues or lack of forensics or lack of what details may be required by a prosecutor. And the other thing is that one of the other unfortunate issues is that cases can be closed by plea agreement too. So if you get a case and you take it to an issuing attorney, it's normally a prosecutor, and they decide to plea it out, well, that case is closed once it's pled out, because they come into the courtroom and then they work out the plea, and that negotiated plea is basically the adjudication of the case. So the case is done. So, and they're supposed to ask the victims with regards to if that plea agreement's acceptable, but it doesn't happen a lot of times, because the prosecutors get to a point where they kind of run the investigation, which that's just a poor investigator that basically wants to get the case off of their case file or their area of responsibility. So they allow the prosecutor just to close the case, even though it may not deliver justice, but they'll let it. But those are good points. And someone else mentioned something.
I'm going to mention the need for improved communication, because if you're the family member, it's really challenging to know how law enforcement is communicating with other resources, such as state entities or the FBI. So just communication, and I've heard that from families over and over again. The biggest challenge they have is just simply communication of the various entities that are involved in some of these cases.
And a lot of times what they'll do is they'll actually meet and confer and discuss minus the families. It's unfortunate, but it is one of the realities of systems. What is supposed to, the way the system is supposed to be structured is that every prosecutor's office should have victim advocates, and the victim advocates are the ones that are tasked with the responsibility of networking with the families and keeping the families up to date with regards to the status of their ongoing case. But a lot of that gets muddied when it comes to tribal cases because of the jurisdiction, because the state has advocates, the federal government has advocates, and even some of the tribes have advocates. So it all depends as to in whose jurisdictional lap the investigation falls into. And once you figure that out, then you have to then find the supportive victim advocates. But every one of those systems receive federal dollars for indigenous victims and victims advocacy. That was one of the things that was bothersome to me when I came up to your community, was that you had families doing car washes to be able to bury their loved ones, when that's not supposed to happen when it comes to the victims assistance funds that are allocated for tribal victims and tribal families. That's what it's for. That's what that money's for. And I don't know if you remember when we spoke at the very beginning, that was one of the things that I brought to the attention of the Justice Department at a conference in Palm Springs, was that they were sitting on over $1 trillion of victims assistance funds for tribal communities, and what to do with that money, because it had compiled and gotten to such a large pot that the current administration that we don't want to talk about was interested in using that pot of money for the Afghan war, because it was just sitting there and no one had submitted a plan on what to do with that money. So the Justice Department wanted input from the tribes, and if there was no input, then it was going to be reallocated for the war in Afghanistan. And I attended the session, and there was only 2 tribes there. Crit, Colorado River Indian tribe was there, and Navajo was there. There was no other tribes there. And those 2 tribes spoke through this panel of justice officials with regards to those victims assistance monies. And, you know, one of the suggestions that we made is, why don't you just earmark it and let the tribes decide what to do with it as far as victim assistance? Why do you have to use it and manage it if it's allocated for tribes? And what we come to find out later was that that money was sitting at the U.S. Attorney's office for each district. And if it was not requested officially and formally requested, that those funds were then, it was allowable for that prosecutor's office to use that funding to balance their budget for the fiscal year, which was ridiculous. But anyway, that's what happened with that particular pot of money. And then it was very unfortunate no one was there, but you know, the short notice and the conference set up and things of that nature, it doesn't surprise me. It's kind of the way they do business. So, and that's one of my challenges with, and I'll put this out there just so everybody is aware. And that's one of the reasons why when tribes develop these task forces, you have to remember that Justice Department does not have the best interests of the tribe at heart. They don't. That's why you have to become your own advocates for your own tribal community and your own victims and your own tribal cases, because these types of shenanigans go on all the time. And our friends in Idaho, they want to work with the feds with their task force. And I said, well, that's fine. That's fine if that's what you want to do. If you want to be friends with them, that's fine. If you want to work with them and collaborate with them, that's fine. But remember, we're at over 6,000 victims, and in many cases because of them. So it just doesn't make sense to me. We got here because of your lack of follow-up and your lack of procedural protocol and your lack of investigative techniques and your lack of oversight and support. So we're supposed to King's X now and everybody's fine. To me, it just doesn't, with my case management background and my investigative background, it doesn't make sense to me. So we'll just leave it at that. So,
well, thank you very much. You know, and I brought that up on supportive families again, who have repeatedly over and over said just this lack of communication is very frustrating. So thank you.
It is very frustrating.
Yeah.
So reopening cold cases. 5 reasons why a cold case should be reopened. Advancements in forensic technology. Previous evidence can now be examined due to technological advances. And we're getting information that technology with regards to treatment of evidence, there's 3 or 4 new techniques developed every year. Every year, new techniques are developed for forensic technology. And changes in interpersonal relationships over a period of time, changes the dynamics of witnesses and their statements and their input. New leads based on case and evidence review. Increased public support and public input, especially if there's an ongoing campaign to get our MMIW, MMIP cases solved. I recently saw in Alaska a billboard that was trying to create new energy for an unsolved case. And I asked an inquiry, is that working? And they said, yeah, we've been getting about 2 or 3 new leads a month. So whenever you develop a new PSA or a public service campaign, you're going to be able to create some new investigative support for that investigations. Improvements in information management, cross-referencing databases. And that's one of the big advantages we've seen recently is the change in how information is managed. So database hits have to be reviewed. And here's what one of the challenges are. There's been a big push to cross-pollinate forensic and crime databases since the unfortunate increase of community shootings and school shootings. So one of the first things that they said was that we didn't want all of these state, federal, and municipal databases not to be able to cross-pollinate. So they started linking them together. But each one of those databases has case information in there, suspect information, vehicle information, so on and so forth, that can be advantageous to the case agent. But here's the issue. Once a case has become cold, hit notifications on perpetrator crime or incident are not followed up on because the case package is just sitting there. And the only way that these computer hits are responded to is if the case is currently being case managed or an actively assigned case. So even though you're getting information and input on that particular investigation, those hits aren't being investigated. And a hit means that you've entered some information into your computer system with regards to whatever method of MO, modus operandi of the crime, or vehicle information, or potential likeness and image of the individual, any of that stuff that you've made inquiries into a database. Well, once the database is cross-pollinated, which they have, you start getting hits or responses to your inquiries. But if a time periods gone by and that case is a cold case, or just sitting in a corner in a file or in an evidence locker locked up, those computer hits are not followed up on. So, and there's a theory, an investigative theory, that all cold cases need to be rerun using new search technologies because of that cross-pollination. And I wouldn't disagree with that. But I can tell you that it's in the majority of these cases, it's not being done because it's either manpower issue, or the case has been closed, or there's not an interest in the solving of that particular investigation. So that's what database hits are. And these database hits, some of them can take years to get a response to an inquiry. And as long as these databases are continually interfacing, which they are, your responses for what your inquiries may just be sitting there. So that's why I think it may not be a bad idea to rerun using all the search technology that's available. So release of information and case access.
Hold on, Chris.
Go ahead.
Real quick. Is there a law enforcement that is applying that investigative theory right now? No. For example, like Washington State, or no?
No.
Okay.
May not be a bad idea. But, when we get to where do we start, that's probably one of the main things, is that you have to kind of glean away your individual tribal cases. And we'll talk about that. So one of the task force's greatest challenges is going to be obtaining access to case information or case files. And there's a couple of methods that are available to a community. And several states vary on releasing closed or cold case information. But there has been some real changes over the recent several years. And I think a lot of it has to do with the pressure that tribes have placed on murdered and missing Indigenous women and missing Indigenous persons. I think that public pressure and that tribal inquiry and support has began to change kind of the concepts with regards to releasing of information. Because I mean, it's pretty much an open and closed issue that they're not looking into these cases. And I think the more tribes continue to inquire, the more they begin to get criticism. And that is totally, in my opinion, that is totally because of the movement of the MMIW, MIP, and tribal lands. Because now they're trying to say, why haven't you done this? So option one, cold case murder investigations in the United States are public record. So once a cold case has unsolved and it goes into a case file, a case package, and it's no longer actively being investigated, then it's considered public record. You can view cases based upon your area law enforcement public access request. Now, what you'll do is you'll go to your departments or the neighboring department, neighboring agency that was the initial responder. So that's the first thing you're going to have to do is find out who the initial responder and what jurisdiction it occurred in. Say, for example, if it was if the victim was missing from Toppenish, you'd go to Toppenish PD and you'd say, I want to make a public access request of this particular victim's case file. Now they're going to, initially there may be some, well, who are you, so on and so forth. But they're going to consult with their attorney, and they're going to realize that under that federal mandate, that information is now available to the public. Now they do have the right to redact information, and they also have the right to charge you. I think normally it's right around $10. And if you can get it on a drive, a zip drive, it's probably going to be cheaper than getting all the documents copied. But that's the first way that you get information. I would suggest, if your task force wants to review a cold case from your tribal community, I would suggest obtaining a letter from the family to allow you to do that. You don't have to, because it's a public record now, but it's more or less you're doing it more as an advisory, or being polite with the family, and being sensitive to their loved one. And so public access request is the first option. Okay, option number 2 is what's called a FOIA. FOIA is Freedom of Information Act if the case is federal. Now, here's the interesting thing. They can't tell you no, which I think is really cool. They can't tell you no, but what you have to do is you have to make contact with the relevant authority and make an initial request and say, we are going to be filing a FOIA with the U.S. Attorney's Office, if that's a federal case, regarding this victim who's a tribal, right? And then give them either a letter or send them an email. That's under federal law. They have 20 days to respond to you. And also within that 20 days, they will also tell you what, if anything, is required for you to receive that case file. But they can't tell you no. Make a request to receive and review specific information, or the entire case file. For example, you want your initial report, you want your medical examiner's report, you want any witness statements, and you want any additional evidence, copies of evidence that was reviewed at the scene. And there's no charge. And the good thing is there's a very simple tutorial on the Department of Homeland Security's website. And again, this was done, in my opinion, this change came about because of the pressure from tribes that said enough is enough. We're going to start asking critical questions about our tribal members' pending or current investigations, which I think is really cool. That's how you bring about change. So that's option 2, FOIA.
So often what we hear when we ask information about cold cases is the federal government is not going to release information on open, or they call these active cases, even though they're cold cases. So I think the terminology, and even knowing that as people outside of law enforcement, how do we re-clarify or make sure that what we're asking for, we're entitled to, I guess.
Yeah, it would be under, there is a, there's case law called Cox versus Collins. And under Cox versus Collins was kind of the COX versus Collins, COLLINS. Under Cox versus Collins, that ruling was the clarification and the support of community members receiving information through the filing of FOIAs, because that information cannot be protected any longer once the case is closed. So once there's a closure of that case, and remember, they have to respond in 20 days. And a lot of times what they're going to admit to is that the case is closed. So it's just it's a hindrance that's put in the way intentionally to try to derail inquiries, but it's pretty much, they no longer have the capacity to do that with communities. And even your local law enforcement agency probably doesn't even know. If you walked up to one of their detectives and asked them what Cox versus Collins is, they wouldn't even know. So you probably walk up to a couple commanders and ask them, explain to me Cox versus Collins and the filing of FOIA. They're not going to know. They will probably spend more time trying to discourage the community as opposed to just filing the information and releasing the information. So it's best to just say, okay, I understand. Okay, I understand, and then go ahead and file anyway, because it's just one of the methods used to keep your arm's length from some of the. Remember what I said at the beginning? What you're going to get in the form of information on these case files is going to surprise you. And I think that's probably one of the biggest issues with cold cases and MMIW cases, is that a lot of those cases were not properly investigated.
Yeah.
And I think I go into that in a minute as to how and why, but and so they're trying to protect that. It's it's their way to protect their poor investigative responses. That's why they're trying to derail you, is what they're trying to do. But these are legal options, acceptable options, and well-known options to get case information. Once they get a FOIA, they have no choice. But if you do get a challenge, or you get a conflict, or you get a response that's unfavorable, your next step is probably in my opinion, the best. I like step 3, and I always use step 3 the most. Step 3 is a file an order to show cause. And what an order to show cause is, it sounds like it's a big deal, but it really isn't. All you're doing is that tactically, and kind of to go back on what your input was, tactically agencies will force you to this method because they fear disclosing sensitive information or material in the case. But what this step does is it makes the individual or agency justify and explain to a judge why they are refusing to comply to this request that you have total right to. And the reason that this step is helpful is because a judge can then issue a court order to release that case file or that cold case information within a certain time frame. And if they do not release that information within a certain time frame, then the judge can move forward and have a criminal contempt charge issued against the individual or the agency. Now, the reason that they're not going to want to do that is because if it's a federal case, number one is federal prosecutors do not want any criminal contempts on their records, because then they don't get the choice assignments that they want, or a choice appointments that they want. So they'll back out. And police departments, it's not good for them to be charged with criminal contempt. So, and it will usually be the administrator or the commander that is the supervisor of the investigating officer. So this is the kind of like your last step effort. It does work. I've used it occasionally, and they don't like a civilian coming in and telling them basically that they're being inappropriate with this information. But it's something you have the right to have access to. They're just trying to derail you intentionally. Any questions on this?
With the dynamics of the task force in the community, like the task force is voicing the voice of the community, is there a way to determine like what cold cases to approach first as a task force, as way not to either step on people's toes or say like this one's more important than this one, if there's like a method to that?
What I would look for is I would look for a couple of things. Number one, family that is still committed to the information and the closure of their loved one's case, the families that still have the energy and still have that positive momentum to get the case solved. Secondly, those that were questionable to begin with regards to knowing potentially who the suspect was. Some information, some quality suspect information would be the second level of priority. The third one would be the one that the case where the community still has a lot of energy or inertia about regard. For example, if there was one that was very outstanding with regards to violence, or one that was everyone is aware wasn't, and they talk about that wasn't necessarily the true scenario as how it played out, but there's been rumor and innuendo around it, that would probably be the third level of case that I believe would be worthy of pursuit. The cases that are really, really old, like in the 50s and 60s, those are just going to be more general review of the case file, the case package. And when we get into the matrix, you can see why a lot of those cases, solvability are really limited. But you will get some information. I'll get into that. That may prioritize your case a little bit. Once you've received the case file, then you need to carefully review all the material and potential filing information. It's best to have a checklist, and I'll go over the matrix, which is the matrix basically is a checklist. But what you're looking for is glaring mistakes or gaps in the timeline, or you may even have to create a timeline. And the important thing about the timeline is not necessarily the time of death, but what you're looking for in a timeline is people that may have had contact along the course of the time frame that they believe before the victim expired. So contacts, individuals that family relations, conversations, history of individuals they were in contact with, things of that nature. That's what you're looking for. Missing materials, you're looking for materials that may be missing, and also interviews that may be missing. You'll read a face sheet. A face sheet is basically the initial report. And in that initial report, you may find some individuals that, like the reporting party, and where if the reporting party was the person that contacted 911, and that's what the initial report is, there should be a very detailed interview with that person that made the initial report. If there's not, then that's probably a good step to start with. Because a lot of times there may be other people there, but they didn't want to come to the attention of law enforcement. So when you talk to that reporting witness, then you'll start kind of determining what other people may or may have not been present. and why they weren't spoke to. If they're not there when the 911 call comes out or when the initial report is met and law enforcement responds to the scene, chances are they didn't follow up to the reporting party's associates to get their perspectives. So that's something that needs to be done. But bear in mind, the older the case is, the harder it's going to be to get certain pieces of information. And it's, that's one of the challenges. So the case matrix will not only show you if the case may be solvable, but it will also show you where you need to start. And the concept is on a case matrix is the more points you have compiled, the greater opportunity to solve the case. That's the whole concept behind an investigative matrix. And this is what one would look like. It's kind of a sample matrix, but you can pretty much do whatever you want. But if you look, it's broken down into evidence, victim, informant, witness, suspect, case, documents. That's the breakdown. And I don't even know what the total point culmination is, but you can screenshot this and take a look at it for those of you that are interested in having a matrix. So for example, is it fingerprints recovered, 5 points, because if you have fingerprints, you potentially have people at the scene. Now, the question is going to be, what happened to those fingerprints? So if you have a case package and you see that there was fingerprints obtained at the scene, but you don't have any report written on whether those fingerprints were submitted for review, or maybe those fingerprints now, because at the time the technology wasn't present. So now you can actually resubmit those fingerprints to find out if there's any person on an active database, depending upon when the case was issued. Positive identification of a potential suspect, fingerprints available from other, and you want fingerprints to eliminate people as well. So that's, and then was there any trace evidence at the crime scene? If there was trace evidence, what happened to it? Was it submitted? Was it reviewed? Was it analyzed? Because you can, at a lot of crime scenes, in most crime scenes, you're going to find fibrous material, because it's very hard anymore, especially with the majority of our clothes being nylon now, and also a lot of cotton-based materials. It's very, very seldom do you not find trace fibers at a crime scene. But the question goes to what was done with that evidence. Was it submitted? Was it reviewed? Things of that nature. Same thing with weapons or forensics. And I tell people this all the time as a joke, but it's sad that I've been out of the business for a number of years now, and I still have I have individuals that are still in prison from cases that I worked, and I still have not gotten the forensics back on those cases. And I've been out for over 20 years. And sometimes the report, they just don't follow up. They don't think there's a need to, do the forensic examinations on some of these cases based upon the detail in the cases. And that's just unfortunate, but that's, crime labs cost money. And I think a lot of families and a lot of victims don't realize that. And somebody has to pay a tech and a crime lab to process evidence. And if you have a small department and that department is on a shoestring budget, that is one of the reasons why your forensic evidence is not being processed, because it's expensive, very expensive. So, families need to bear that in mind as well. Victim identification, things of that nature. Informant, if there was any, paid or otherwise. Now, there are times where cases you're going to see that when you read a case file, you're going to recognize from the interview of individuals that they may know more than they let on at the time of the investigation. Now, what you're looking at potentially, not always, but potentially, you may be looking at an individual that may be a working law enforcement informant. And because they're a working law enforcement informant, they will not detailed interview them because they don't want out, they're trying to protect their informational source. So, you know, you'll find that in cases you'll review and you'll get that instinct saying, man, this guy seems, or this lady seems like she knows a lot more than what she's brought out in this interview. Well, if the interview is cursory, there's a reason why that interview is cursory. And if you don't find a detailed taped interview that's been transcribed from that individual witness, it may be because they may have some, they may be an informant for law enforcement. So keep that in mind. Doesn't mean you can't have them re-interview or speak to them if the case is closed. Witnesses, there's different types of witnesses. There's direct incident witnesses, there's support witnesses, there's family witnesses, and a lot of times these layers of witnesses are not properly interviewed for some unknown reason. It's either the haste of the investigation, and here's one of the things that a lot of community members and families don't understand is that a investigator, a case agent, will get a feel for a case. And when they get a feel for that case, and that feel for the case is not solvable, you'll see them in the form of their investigative work, you'll see them start pulling back from being aggressive on the interviews and the investigation and filling out. And I think that's one of the reasons why a lot of individual investigators don't like using a checklist, because if you have to complete this with every case, it is quite a lot to do. But again, it all goes back to justification, and it always goes back to working on behalf of the victim. So just bear that in mind. Yeah, and you'll find this when you start opening these cases. I saw one, they asked me to consult on a murdered retired BIA agent and in North Dakota. And they said, would you mind looking at the case file? And I thought it was going to be a massive case file. And I said, no, I'll look at it. I'll review it real quickly. But I don't know how much I could do because the individual had been expired for quite some time. I said, but sure, I'll look into it. So I looked into the investigation. First of all, it was only like 6 pages of material. And I was like, are you kidding me? 6 pages? That was it. That was their entire investigation. And it, to me, the way I read it, it read very suspicious, because they said the method of death was suicide by overdose, but there was no pills in the house. And on at the crime scene photographs, there was a pill bottle on the ground, but it was like very expired for many years. So it looked to me like it was placed there as opposed, and then the pill bottle was never processed for fingerprints. So there was a lot of questions that I had with regards to that particular investigation, mainly because it was only 6 pages, but nonetheless, you know, you start using the solvability matrix, and you know, it kind of gives you some direction. So any question on the matrix?
I had a clarification question just for our audience that is listening to this podcast and not viewing it. Chris has a cold case solvability matrix. Let's try that again. Chris has there's so many C's. Chris has a cold case solvability matrix up on the screen where there's a series of items as well as the score that aligns with it. And on the top, it says date of incident. We've been talking about cold cases here, and I just want to clarify for our audience and for myself, what is a cold case? Is it have to be past a year? Is it longer? Is there differences in what the county considers a cold case compared to like FBI?
And that's one of the challenges, is that dependent upon, and a lot of cases in tribal communities, there's layers of jurisdiction, and every jurisdiction will have their own methodology in determining whether it's a cold case or not. So it's got to be basically reviewed as a case by case issue. That's why you make the inquiry initially to the closest law enforcement agency where the report initiated, and you'll find out what their procedure is with regards to their storage of their closed cases or cold cases, whatever they may call them. So it's got to be on a case-by-case issue because of this layering dynamic with jurisdiction in tribal lands. So that's my best response for that inquiry. But that's a good question. It's a really good question. Each jurisdiction is going to be different.
Well, and then similar to the previous question I had regarding communication, increased communication and improvement in communication, that also goes to this matrix that's been put together. I think it's important to highlight the role of communication between these different jurisdictions. And what are those jurisdictions, and what is their methodology? And as you said, everyone is going to be different, but what are they doing to help seriously solve some of these issues? And it sounds like, that may not be on the top priority, of some of the law enforcement agencies. So when you think about it from a family perspective and you begin going through this, and would you say you had a cold case file you reviewed and you had like only 6 pages and it was suspicious?
Yes.
So, yeah. So that is a major issue. It's just the communication again. I'm looking at evidence, victim, information, all of these categories. And just thinking about every step of the way, again, about communication and who has what, which jurisdiction has this. And as you get into cold cases, then you have various agencies that are part of the process, that can be a part of the process if brought into the cold case. So there's so many, I guess, variations or that you can take a look at any cold case.
One of the things you can do, it's good input, Patricia. One of the things that you can do to find that out, which was prompted by your inquiry, which I think is really a positive idea here, is that each agency is supposed to be managed using rules and procedures. And that is how departments are supposed to manage their personnel, their casework, and their processing of information and their work with the community. So what you can do is you can go to an agency, or you probably can even go online to that department and pull up their operating rules and procedures, and actually go to the segment of investigations and scroll through those pages and see what their process is with regards to cold cases. It should be online. I know our agency, or the agency I used to belong to in Arizona, in Tucson, they do have their rules and procedures online. So you can, and that includes their investigative rules and procedures. So you can go through that particular chapter and see how they're supposed to manage those jurisdictional issues. However, you may also bear in mind that there could be some historical conflict as well in law enforcement, and we're seeing that. Unfortunately, we're seeing that play out now with this last school shooting, where you can read between the lines. It's not even subtle. It's pretty obvious that some of those agencies don't like each other, based upon the release of information, the undermining of press releases, and also the community comments regarding procedures and responses that certain agencies took. And what that tells you is that not every law enforcement agency in that jurisdiction get along, and they're not on the same page. And historically in Arizona, we have the same issues as well. There's certain agencies that you don't like working with, and you distrust them, and you don't readily exchange information with them because you don't like them. And that's just the nature of law enforcement. So that's good insight, Patricia, and that's also very true. You may find that in your cold case that you're reviewing, and there may be some real obvious oversights in networking with regional or local or federal law enforcement. And it may be because they don't like that agency. And because they don't like that agency, they're not going to give them any of that. That's just the nature of police work, unfortunately.
Mhm.
I mean, they can tell you that you have to work together until they're blue in the face, but that doesn't
Right.
mean you have to work with them. So,
Well, it's unfortunate that, when you take a look at grant applications, that organizations say that they will work together, and that's not necessarily true.
it's not.
And so that is an issue. And before you go on, I just had another question about examples of costs that families would have to bear in terms of getting forensic evidence, because it's not just up to, certain individuals. There's certain programs or specialties that are involved here. I'm just, just one example would be a forensic ontologist and perhaps anthropologists as well. So what are some examples of costs that we're talking about here?
Well, you're talking about, it depends on what you want to do. If you want to have for example, if you want to do say you have a case and you want a forensic examination of a cell phone, and you want the phone, what the term is to have the phone cracked. And by cracked means to open up the hard drive and review all of the phone history, and also review the chip, the microchip in the phone. Usually runs between $3,500 to $4,500. Drug analysis can be anywhere from $1,000 to $1,500. It all depends. Some of the more detailed, like forensic review of a handgun or a weapon that may use that, could be several $5,000 to $8,000. It all depends on what you're looking for. If you want matching of slug to injury or blade to individual, there's costs associated with that as well. So, which brings us to our next point, is the forensic pathologist report.
Okay.
And that's probably the best bit of case detail that you're going to get, is when the pathologist reviews the victim and determines specific information. And that's a good starting point. And it also will be able to assist the reviewers on whether the details are in the investigation, because you'll get information as, for example, you get what the injuries that were sustained. You can determine the type of weapon from the pathologist's report. You can determine the degree and the use of force to, apply that type of injury. And usually what happens is you can determine whether there was a, anger or frustration or just rage involved by the degree of force that was used to make the type of injury. Defensive wounds by the victim will also be able to give you some information with regards to whether or not they may or may not have known the perpetrator. Because what you're looking to do is you're looking to have the story retold in the form of evidence from the pathologist's report. And that information, a lot of times, is not released to the public, because the case details in most investigations are protected, so that when you talk to individuals, their information that they give you aligns with the physical evidence of the pathologist's report. So that's one of the reasons why they don't release certain kinds of information. But once it's a cold case, and remember that the objective is to generate inertia and generate interest And that interest and inertia is supposed to create more support of the victims and bring more individuals out to be able to be interviewed. So we're beginning to release some of that information. For example, like the nature of the injury and the degree of force that was used to apply those injuries to the victim is going to kind of stir up the community and may bring up some additional information that was not initially covered during the preliminary or initial investigation. So, and you have to do that on a case-by-case basis. I would say the task force would sit down and talk about, well, how much of this do we want to bring out? You know, we want to, you know, you want your victim to have community support so that they're interested to become involved. You want to develop sympathy for the family, sympathy for the victim. And that'll bring more inquiry, more insight, and more individuals willing to participate in the process this time. The previous time may have been when the case happened, it could have been fear, could have been intimidation, could have been not wanting to get involved with the criminal justice system. But over time, you know, guilt, victim support, family support can really begin to work on behalf of getting information. Remember, the departments aren't going to go back and do that type of detailed work on these cases, because again, closed cold means I don't have to work on it anymore. And that's unfortunate, but it's reality. So identify and record all this is where to begin. Identify and record all unresolved cases within your region. The next step I would do as a courtesy is reach out to the families and get their input on whether they want to support you or they want you to take on the responsibility to begin to inquire about their case. And that would be a good time to get some type of documented letter saying that you know, the family wants you to look into certain aspects of the investigation or just to review the cold case. Lobby to have your regional cases entered into an unsolved database. In some states, it's the norm, and a lot of states it's not. A lot of states, the cases are considered dormant and they stay that way. And remember, one of the things you're going to do when you look at that case file, you'll see if there was any database inquiries that were made by the investigator previously. Getting that information into a regional or national database may be very helpful to reignite some interest and support and even some investigative needs on that particular case. Conduct a needs assessment to ensure that you're getting the highest quality of investigative response. I think we're at the point now where if you have a agency that consistently closes cases and consistently doesn't do enough for the victims and the families, that I think the communities have gotten enough respect and developed to the point where you need to start making those types of questions and presenting those types of questions. Like, why do we still have this particular person working these cases when we don't have a track record of success? And one of the things that they're doing, I saw this, so it was signed, the bill that was signed into federal law is a couple of weeks ago, was that departments can no longer hide unqualified or underperforming officers and detectives, that they now have to release their information if the community inquires about them and not allow them to lateral transfer to another police department. And that happens so often. I can't tell you how many times people escape consequences by laterally transferring to another agency. But now they're with this new law in place, that they'll be able to limit that, and communities will be able to access particular personnel files of individuals, which I think is long in coming. We should have done that years ago. And it doesn't matter what level of investigator you are. And if the region has substantial number of unsolved cases, it's the community can begin to push to develop a cold case unit, just individuals that are actively assigned to work cold cases only. That's their only responsibility. And then demand cross-pollination. Begin to ask for that layered oversight of these cases and have the community have more input, more access, more inquiries. I think that's what this whole movement is about, in my opinion. This entire movement is about accountability. And it's, in my opinion, it's something that should have been done years ago. And I believe that that's one of the key issues to get closure your families, have these inquiries responded to, and get support for missing and murdered Indigenous women and Indigenous persons. Conclusion is, I hope that War Cry Podcast and National Violence Prevention Resource Center has been of service. I appreciate this opportunity, and I hope that we've been able to provide some insight, some experience to you and your community, and to be able to work with War Cry Podcast was a real privilege for me. And I hope that we continue. If there's any other interest or information, please feel free to give us a call. This will conclude our Micro Method Workshop series. If you have interest in any other additional information, please contact War Cry Podcast or National Violence Prevention at gmail.com.
Actually, I have a couple more questions that I think my co-hosts do too. You just stirred a whole lot of questions with us with this content.
Okay.
I have a question about when you talked about going to court and filing an order to show cause, is there an example of families or tribes that have done that, or even press outlets? So like if War Cry Podcast sort of file that, is there any example of that out there now?
Yeah, there's a couple of agencies that I could pull the inquiries down and even send you the format that they used. Absolutely. I think that's kind of the next level that needs to be taken with regards to cold cases, is filing these release of information and FOIAs in order to show cause. Absolutely. I don't understand why, and it might just be my being naive. I don't understand why tribes have not done that on behalf of victims in their communities. It's just, it would seem the logical and the right thing to do is to tell us what the case status is of all of our tribal members' cases historically. Where are the cases, and why are they closed? Why are they pending? What's missing? Why aren't they being issued for indictment?
The other question I have is related to the matrix and, having evidence that because of technology, we can resubmit through new technology and have additional forensic information about this.
Right.
We see that here, even locally. I understand there's even agencies, local neighboring agencies to the tribe, that have even 3D modeling that can recomplete a scene to a 3D model that you can go in and see it. And our cases actually technically used to go through this with the tribe. But when PL 280 happened and retrocession, those cases that used to go through that as a normal part of procedure, there's no memorandum of understanding at this point that occurs between our neighboring law enforcement agencies that have these forensic tools and our tribe, Yakima. So I just wondered if you have seen examples of memorandum of understanding that's happened as a result of task force action, or just, is that a pie in the sky kind of thing that'll happen, or is that a realistic goal to have for task?
No, absolutely. That's an excellent point. And that's one of the things that we do is when we initiate our task forces, we go through a series of MOUs, MOAs with agencies that we think serve the best interests of the tribal community, depending upon what task we're taking on. One of the things that we're working on right now in Puyallup is the juvenile justice system in Pierce County that's not advising the tribe with regards to juveniles being charged. So we're developing an MOU, MOA with them so that we can be on the same notification track once a tribal juvenile is detained. And then the tribe can then provide resources as opposed to having the state manage the wraparound and the follow-up for a tribal juvenile without the family even knowing. So yeah, it depends on what task you take on. And once you accept the task, then you begin to find out within the framework of your response which agencies you need to collaborate with, and then address each one of those agencies and go over an MOA with them and have them sign off. Unfortunately, with most tribes, I don't know what Yakima's protocol is, but you have to take the MOA, MOU to tribal council. It just can't be the task force. So, but yeah, that's a great idea. And you may be able to reignite those processes historically. And I think a lot of times things are dropped simply because there's not an interest anymore. So, and once those old historical MOAs, MOUs expire, then if no one picks up the responsibility or the task, it just kind of just goes by the wayside.
Hey, Chris, I really appreciated this engagement with you and your law enforcement background. And I've been pleased when you've also interpreted what, some of the law enforcement language and jargon is. I would like to see, this similar program redevelop for families. Families would, gain a lot from this kind of training. And I would urge you to consider that, and perhaps we can all work together to advocate for that as well, because there is a need for this kind of information, education for families.
That's an excellent point, Patricia. I was mentioning to Robin before we went online that I was requested by the IHS national conference. It's in September to actually do that, to do a MMIW, navigating the criminal justice systems for families piece. So they're seeing that, and that'll be in Rapid City at the end of September. But I think that's real important, because if families don't know and they don't realize that there's a process in place and there's things that they can do, and there's actually things they can force people to do with regards to their loved ones' cases and investigations, I think they just carry the burden of not being able to get their questions answered, and that turns into guilt. I see that with a lot of families. So
Right.
I think those are great things that families need to be aware of. So I appreciate your input.
Actually, just for your information, the Department of Health and Human Services had a tribal consultation session, and there weren't a whole lot of people on there. And so I was toward the end, I thought, well, I'm going to say this because I think it's important. In some cases in rural, remote communities, you don't necessarily have immediate support or services. And so I made the recommendation because the funding through HHS that they should consider, like a Head Start program, which is in many of our rural communities, to place some kind of support system there for families in those kind of programs that are out in the rural communities. So just want you to know that we'll continue to advocate for that kind of support, and
Awesome.
just say I really appreciate your efforts.
Thank you.
Hi, Chris. I thank you so much for doing these workshops. These are amazing. And thank you so much for being our guest previously. So the question I had, it's kind of more like if you could reiterate a little bit. So you had in a previous portion of this presentation talked about like private investigators in order to help. So when you're talking about cold cases, could you maybe reiterate perhaps how private investigators could aid in this process of perhaps either opening up a cold case or a case? And then I think you had also brought up like who pays for that and how does that get funded?
Well, there's a couple of ways that's currently happening right now. There is just a national group of retired detectives that are doing pro bono private investigation on behalf of families. And they actually have a website that you can go on. The only challenges is they responsibility of obtaining the case information is the families, and then you refer it to them, and they will use their network to begin to make inquiries. So the pro bono one is, you are using individuals with history and background. These cases take a lot of legwork, so you have to actually make one-on-one inquiries, and we haven't, even though we have accelerated with technology, a lot of the things we can do, there's still agencies that you have to be able to go individually to make some inquiries and follow up on some specific pieces of evidence, especially when it comes to doing interviews. You're not going to get that depth of interview if it's over the phone, or if it's even on Zoom. So one of the things that we've been requesting is to be able to provide funding for communities, tribal communities, to hire PIs. That way it's not burdened by the family to have to come forward with the funding. And as of right now, the idea is you make the inquiry through the federal prosecutor's office. And if the federal prosecutor's office finds that it's a valuable asset to that particular case, then they may release some temporary funds. But it hasn't been fully developed like it should be, because I think, and then there's some tribes where tribal members have come before council and actually asked tribal council for funds to allow them to hire a private investigator. So, and there's been some tribes, particularly in the Great Lakes area, that have supported families to hire PIs. So there's been a couple of methods that are being used, but I do believe that it falls to the responsibility, in my opinion, the Justice Department, to begin to release funding in the form of grants to tribes to be able to hire private investigators to do some of the legwork, if not all of the legwork, on some of these cases, just to see where the cases are going. And again, it may come back to what I said earlier, is that they're trying to protect the information that's in the case file. So, but I think we have to overcome that and realize that, hey, that's just a nature of these types of cases. You're going to have some people that were either underqualified. And, it's funny because the FBI already went before Congress and said that BIA law enforcement is undertrained, can't manage crime scenes, and are untrustworthy when it comes to veracity to be able to file cases. So, I mean, how much more do you have to say to be able? I mean, I don't know what they're fearful of any longer. If feds tell that to Congress, then that's pretty much, it pretty much encapsulates what the challenges are. So, and the families know that, tribal families know that. I mean, every tribe that I work with, they tell me about the lackadaisical, if any, response at all to their investigations and their inquiries from PIA. So it's just, it is what it is. Let's move on.
There's so much important information that was covered over these micro workshops. And thank you so much for Chris and my co-hosts for, joining me in on this conversation and providing this information to our tribal communities. Again, we are War Cry Podcast. We're an Indigenous-led podcast surviving under the duress of colonization and intergenerational trauma towards self-determination. If at any point during this session you need culturally appropriate advocacy or support, please contact Strong Hearts Native Helpline at 1-844-7-NATIVE or chat online at strongheartshelpline.org. I'm Emily Washings, and thank you to co-hosts Robin Peebushy and Patricia Whitefoot. Thank you again to our guest, Chris Cuestas with the National Violence Prevention Resource Center. For our credits, we have support for this micro workshop series from Na Ilahi Fund. It's edited and produced by Robin Peebushy of Peebushy Studio. Music by Lee Sekokwaptiwa. Logo and shirts by John Olney Schellenberger with Native Anthro, where you can also get our merch. Please like, subscribe, leave a comment. If you have a question, we'll let Chris know about any of these micro workshop series. Again, thank you so much.
Thank you.
Thanks, Chris. Thanks, everybody.